Justice of the Appellate Division, 4th Department. Here it is, here it is, here it is. All persons having business before the court with law area of the defense is going to be heard.
Thank you. Please be seated. The first case on for argument, People versus Rivera Mateo.
I think it's just me here this morning, Your Honor. So, good morning. May it please the court. Kaylin Porter on behalf of the people. Unless there are any questions from the panel, I'll rest on my papers.
No questions. Thank you, counsel.
Thank you.
Case 590, People versus Acosta.
Morning, Your Honor. Mark Davison representing Jeremy Acosta. I'd like to focus on point one of the brief, the issue of the canine search. This was a stop for unlicensed operation of a vehicle. They had known that Mr. Acosta didn't have a driver's license, or it had been suspended years earlier. They used that as a pretext to stop him in February of the year in question. They did a canine search with his consent in February.
Are you saying that they were not entitled to stop him?
Oh, and no, I'm saying they were entitled to stop him. But
Your argument is that there wasn't founded suspicion for the canine sniff.
Correct. That it never escalated, and I use the February incident as an example of how there was no founded suspicion. They at that point they had
They had information from two confidential informants before the stop, right?
Back in December of the preceding year, they had that information. They used that to get the GPS devices. They attached them to the car. They followed him around to various locations, and this was all before they pulled him over in February. They pull him over in February. They say, if you let us do the canine search, if we don't find anything, we'll let you go. They strip search him. They find nothing, even though the same dog alerted on the car.
So how is all of that relevant to the April stop and canine sniff? If they had information from confidential informants, they had an authorized GPS tracker, why does it matter that they also did this in February and let him go?
It shows how stale the information was, because in
But
between,
he was still driving without a license. They had the right to pull him over.
correct. They had the right to pull him over,
And
but
they had GPS information showing he made regular and routine stops suggestive of drug transactions.
correct. But that was all before the February stop. There was.
But they had it again at the April stop.
It was still there, but it was stale by that point. They're using.
So that's really, your argument is, look, yeah, that information was fine back in the earlier stop because it was fresher.
Yes.
But they can't just keep that same information in their pocket and pull them over whenever they want, even though, and say founded suspicion.
Exactly.
They needed something fresh, something more current, something closer to the pullover. That's your argument.
They not to pull him over, but to do the canine search.
I said to pull over. They can pull him over because they knew he didn't have a license. But to do the canine sniff from the outside of the car, to do that initial sniff, you're saying that they needed something fresher.
Yes.
Okay.
Yes.
Well, they had it, though. They had day of observations in April, didn't they?
They saw him. They parked across the street from his apartment. They saw him go into a neighbor's apartment. They saw him come out, get into his car, and drive away. And those were the observations that day. They were just.
He went in the neighbor's, he closed the curtains that had been left open by the neighbor, went into the neighbor's residence without knocking.
And the testimony at trial established that they were good friends, that he had a set of keys belonging to the neighbor in the car. That was one of the two sets.
Does the information of what happened at trial mean anything in terms of what the police officers observed at that time? In other words, the trial takes place later. We're
Correct.
concerned, are we not, with what the officers had at the time that they stopped the vehicle and then decided they had founded suspicion for purposes of the canine sniff, right?
Right. But they had been assuming that there was something going on between him and the neighbor. And that's what, and they saw him, go in and out of the neighbor's apartment. But that doesn't amount to founded suspicion. There's no indication that day. There were no informants saying who had set up a drug buy that day.
Can it be argued that the suspicion continued even after the February stop? Because even though they let him go in the February stop and no narcotics were found, they found a stash can, they found 5 cell phones, they found other indicia that he was engaged in trafficking. In February.
Not in February. No, not in February. Not until April. Not until they searched the. That's my recollection of the record is they only found the stuff, the stash cans and the cell phones when they got the search warrant.
Not in February?
Not in February. In April, after they got the search warrant, they searched his apartment. They searched the neighbor's apartment. They searched the laundry room.
That's when they found the toolbox and the key.
That's where they found the toolbox, yeah.
Very good. Counselor, would you hit your last argument on the harsh and severe?
Yes, as I noted in the reply brief, this court has several times recently struck down a sentence as harsh and severe when it exceeds the plea offer, which in this case was 12 years. He ended up with 18 years. Even if it's not an abuse of discretion by the trial court, it goes beyond what he was offered, and there's...
Oh, he's not entitled to what he was offered on the plea automatically after going to trial. That's not your argument.
That's correct, but...
And I don't think the cases you're referring to, without specifically saying that the ratio between the plea offer and the sentence had any bearing. It's just the overall sentence in and of itself, the court found harsh and severe based upon the criminal record and the crime that was committed.
That 12 years would have been a perfectly appropriate sentence.
Was there any new information that the court had that it didn't have at the time that the 12 years was proposed? Let me be more clear. From the time that 12 years was offered to the time of actual sentencing, was there any new information that could have justified the increase in the sentence?
Not that I can see. From my point of view, the new information was Mr. Acosta coming in and testifying and explaining what had gone on.
Okay. Thank you, Counselor.
Good morning, may it please the court. Amy Hollenbeck on behalf of the people. In regard to the first argument, our position is, as outlined in my brief, that the information that was contained in the search warrants, other than the canine sniff, was sufficient to establish the founded suspicion, and that's what the lower court found. It seemed like clear-cut indicia of drug selling activity, at least enough to support what was enough to support the warrants for the house and the car, so clearly then would be enough to support the reasonable suspicion. In addition...
Founded suspicion, right?
Founded suspicion, yeah. Excuse me. In addition, there wasn't anything in the car that led to the criminal charges. All of the drugs were in the toolbox in the laundry room. And then there were some other items indicative of sales in the house, in the apartment. The only thing they got out of the car was the keys, which they used to open the toolbox which all that did was save them from having to break the lock. So even were the court to have determined somehow that the tools were the keys were taken inappropriately, it wouldn't result in suppression of the other items because the defendant had no standing on the toolbox in the laundry room.
So the fact that he had the keys in the car wasn't a factor about controlling the toolbox?
It was one of many. His DNA was the main source of the DNA on the fentanyl and the heroin packaging. It was only his DNA on the cocaine packaging. His fingerprints were on the outside of the box, on the baggies. So the keys were utilized in that way and were discussed during the trial, but there was a lot of evidence about his dominion and control over the toolbox that he had no standing to contest the search of.
Very good. Thank you, counsel. Case 591 and 592, People versus Lopez Contreras.
Morning, Your Honors. Kathy Reardon for Mr. Lopez Contreras. Unless the court has any questions, I'll be resting on my brief this morning.
Thank you, counsel.
Morning again, Your Honors. Unless there are any questions from the panel for me, I will do the same.
Very good. Thank you, counsel. Case 593, People versus Thomas.
Good morning, Your Honors. May it please the court. Quickly, I want to address point 2 of my brief. I note that I'm only arguing that the people did not meet their burden of establishing the value of restitution for the $75,000 ring, not the other items. Ms. Clark's testimony regarding the value of the ring was so conclusory that it did not meet the preponderance of the evidence standard. I asked the court to rely upon the Third Department's decision in Wilson, which is cited in my brief and respondent's brief. Here, Ms. Clark did not describe the metal the ring was made out of or the setting of the ring.
But she did testify to the fact that she purchased it at a silent auction at $70,000. She paid $75,000, and that was 10 or 12 years ago. That's what her testimony was, correct?
Correct, but I don't think that meets the preponderance of the evidence standard. She described the ring as a 7-carat diamond ring, 5-carat emerald cut ring in the middle, which is, rounded to the whole carat, is a gross estimate of the weight of the ring. And she described the shape. And as I explained in my brief,
But she did say the declared value at the charitable auction was $70,000 and that she paid $75,000 years before.
Right. But again, as I explained in my brief, the value of diamonds are highly specific. And there are certain characteristics that determine the value of a diamond. And here there's a lot on the line. We're talking about $70,000 of restitution.
What was the proof put on at the hearing relative to the diamonds and the cuts and the value of the diamonds in response to her testimony concerning the value and her experience at the auction?
Do you mean?
In other words, what proof was offered to dispute her value?
By the defendants?
Yeah.
There was no proof offered. But again, it's the people's burden to show by a preponderance of the evidence. And the argument I'm trying to make is she said in her testimony that she wore this ring for 15 years on, in her words, most days, and yet the people didn't even offer a picture. She was able to supply the receipts and other evidence for the...
Whether she wore it or not, how is that relevant?
Well, I'm just saying they didn't even supply a picture to show what the ring even looked like, and she went...
So that would have helped the judge determine the value by looking at the ring.
Well, if she had a picture, it could have helped the judge. She could have also, she had to go to New York City to replace the 2.5 carat diamond earrings, so she could have asked the jeweler there, can you give me an estimate?
So you're saying that there are other things she could have done to buttress the proof that she put in, that maybe she could have gotten to the burden that she was needed to meet, but she didn't get there?
Right, because she didn't even testify about the metal that the ring was made out of. That obviously affects the
We'll take a
value.
look at that, Counsel.
Could I just want to address one other thing really quickly,
Proceed.
please? Okay, so obviously the court has decided the co-defendant's appeal and affirmed the restitution award and relied upon Osborne. In that case, it was a pastor who stole money from the church. I don't think, I respectfully submit that that case is not applicable to the $75,000 ring, because in that case, there were voluminous church records and there was an auditing firm, and an analysis was done of those church records to determine the restitution amount. And here, again, she had no proof other than her testimonies to support the value of the ring.
Very good.
Thank you.
Thank you, Counsel. Case 594, People versus Hill.
Good morning, and may it please the court. Morgan Mayer on behalf of the people. I'd like to focus on 2 points today. First one being the illusory nature of the statement of readiness. Defense counsel in
What did you say, the what nature?
the illusory nature of
Illusory
the
nature,
statement of readiness. Defense counsel argued in the underlying motion to dismiss that because we declared unready at the August 4th, 2021 hearing, that rendered all statements of readiness issued prior illusory.
So what changed between the prior statements of readiness and the one of now being unready?
Nothing, Your Honor. The statement of readiness initially offered on October 9th of 2019 was entered soon after the victims testified before the grand jury. Everything was very fresh, and the only difference between then, when that was initially entered, and the ultimate declaration of unreadiness on August 4th, 2021, was that the people had not sat with the witnesses, the 2 minor victims, to discuss the case with them.
But that's totally within the people's control, wasn't it?
Yes, it is, but it was our understanding that there were 3 cases ahead of this case set for trial. Upon discussion with the trial attorneys in our office, none of them were expected to, or all of them were expected to go forward. We were informed by the court that no pleas would be accepted. Last minute, all 3 of them pled out at the last minute. And based on a conversation between the district attorney and the chief assistant district attorney, it was decided, because this case is 4th, we're not going to start to ready the victims until even
And that
it's
could
in
be
the
a
third
good
slot.
faith argument for why you did not ready the victims and why you were not ready for trial. But does it matter that it seems in the record that the court was very clear that, in other words, be ready to go, because if we hit this case, we're going. And does that change the argument?
I would submit that it doesn't, Your Honor. It doesn't negate those prior statements of readiness. The original one was filed soon after the victims testified at grand jury. It could have gone to trial the very next day.
That's March 28th, 2019? That's the letter notice of readiness?
That was the initial, and then the case was re-heard before the grand jury and re-indicted. So this one was October 9th of 2019. The court seemed to disregard that March entry of the statement of readiness. And then another statement of readiness was entered, I believe, January 27th of 2021.
But you weren't ready because the witnesses weren't prepared at that date.
That's correct, Your Honor. We did not have the witnesses prepared, but we had the case made. It was a matter of getting the witnesses, sitting down with them. We had asked for a date certain. We had anticipated the other trials running. So while, yes, the witnesses were not prepared that day, it's not that we were just sitting on our heels about the case. Throughout the entirety of the period while it was pending, We had been turning over discovery material. We had been continuing in negotiations. We had been in contact with the victim's mother. We had been discussing a potential expert witness. We had been speaking with law enforcement about this case. It was just the...
But this isn't a situation where when the court asked and told you to get ready for trial, that this child was on vacation or out of town or something else. It was you hadn't prepared the witness.
On that day, correct.
Well, you had never prepared the witness.
The witnesses were prepared. They were aware of what was going on. They had testified twice before the grand jury. They were aware of the situation. They were aware of what was pending before them. It was just a matter of sitting them down, saying, this is the courtroom. This is how the trial process is going to work. We're going to testify.
And you couldn't do that over 4 days?
Your Honor, I would not be able to make a statement towards that.
Okay.
So again, we would submit that that does not render the statements of readiness illusory. Next, I'd like to move to the exceptional circumstances argument that was made. I kind of touched upon this earlier, the issue of these two minor victims.
But Counselor, I find that argument to be a little more troubling compared to the first one. You know, normally exceptional, we're dealing with an unavailability of witnesses along those lines. This is a witness that's in your control, presumably at this point. And then based upon your statement here, that any child victim case would automatically qualify because they're all going to have the same features to it. They're going to have the same age, what took place, the sexual assault, not being familiar, and all the other aspects of it. And I didn't find a case, see a case cited by you that specifically those conditions of a child victim automatically qualify for the exceptional circumstances.
Right, Your Honor. We are unable to find a case speaking to that as well. However, the cases that we did submit to the court deal with the potential trauma that these children are facing.
But they are, in any of this kind of case, they are.
Correct. Correct. And we're not trying to say that if a trial is first on the calendar, if a trial is second on the calendar, you should not be preparing witnesses. But because this case was fourth in line, we felt, the district attorney felt that it was remote enough that having them prepared could open a can of worms, so to speak.
I find it troubling, as my colleague pointed out, there was 4 or 5 days for the trial date that could have been prepared. I find that portion troubling that you couldn't answer. But I also find troubling the fact that the court puts a case on, the fourth case on, a child victim case. Normally those are DWIs, white collar crimes, or the police are available, to prepare a child victim on a fourth that has a little chance of going. How many times you put the victim through the process? And this court's not blind to understanding the child victim case.
Thank you, Your Honor. And that was the concern with this as well.
Anything further?
No, Your Honor. Thank you.
Thank you, Counsel.
Good morning, may it please the court. John Sarando on behalf of the respondent. I think when you look at the complete record and the statements of the district attorney, they did not prepare a proper record to justify their being unable to proceed to trial. It's basically a situation where they said, getting down to the last part of it, the 28th, you're going to go to trial on the 9th. They didn't say anything to the judge at that time. The judge is saying to the defendant, you be here because, with your lawyer, because you got a trial starting on the 9th. The district attorney said nothing. They had another pretrial on the 4th, and the district attorney then said they weren't ready. When you look, the law requires them to be, in fact, ready to proceed. When they basically say, it's been almost 3 years, and we haven't talked to the witness. I think there was a reference during the transcript where the judge said, have you even called the mother? And they said no. They hadn't called the mother. And when they're not actually ready for trial, you treat it as a nullity, obviously. And I think their language, they were going to be ready for trial when they were really ready to proceed to trial. That's not the standard
Now,
in
they
New
asked for
York.
a date certain on this case, right? Of the judge, and the judge didn't provide it to them.
Right, he
Right.
told them, you're not going to have a date certain. Well, he said, I think what he said was there was no request for a date certain. He was unable to find a request for a date certain.
Yeah, I think the
That's what
district
he
attorney's
said.
office said they asked for that, but there was no written documentation of that request.
No, or written documentation of a denial.
Yeah.
So when they say they're really ready to proceed to trial, I don't think that is the standard. And when you talk about exceptional circumstances, I think there's two categories. The unavailability of evidence, it's over there in the lab or something, and the additional time to prepare due to exceptional circumstances. It's something beyond their control. This was not beyond their control. This was totally within their control. They didn't exercise due diligence, and their claim, it's improper to subject the two victims, 15-year-old at the time, to continuously relieve the trauma that they had several years to process and heal from on the off chance that the trial would run. Well, that's not the standard. Number two, the material that they submitted to this court wasn't submitted to the trial court. And there was no, I think that the judge said there's no documentary evidence relied on by the people or submitted to me. They could have had a doctor's certificate or something. And when you look at all of the cases that they cited, the 5 cases that they cite, the record was clear that there was a reason why the DA couldn't proceed. And you don't have this here. I know all of you are young, a lot younger, and I don't know if you remember calendar calls. They used to have calendar calls. And as a young lawyer, I can remember sitting in calendar call, and the attorney's case was called, and he'd say, ready. And as soon as the judge acknowledged that he said ready, he'd turn to go sit down, and he'd say, unless reached. And that, I submit, is what was transpiring here, and we would ask that the order be affirmed. Thank you.
Thank you, Counsel. Case 595 and 606. Oh, excuse me, that's submitted. My apologies. Case 596, Hogan Willig versus Stormville Fire Company.
Good morning. May it please the court, Jeffrey Novak for the appellant. We're here to argue the disqualification of the firm in total to self-represent in this action. And I wanted to just briefly go through a couple of the issues as it applies to Rule 3.7, and not only its application in this case, but perhaps its applicability to self-representation of law firm cases in general. The procedural history of the case being that Judge Nowak initially disqualified 3.
Well, I think we're familiar with the procedural history. Really, doesn't this, it seems to me this comes down to really the question of whether there was demonstrated apparent prejudice and how that phrase should be interpreted by us and applied by us, right?
I think that that's correct, Your Honor. I think the respondent would wish that prejudice be an extremely low bar. I think the cases, and we cited the Bodkin case in particular, that language that the prejudice has to be so adverse as to essentially you cannot allow both of these testimonies to occur. Now, I would submit that the 4 items of supposed prejudice that were cited by Swarmville do not meet that standard. And if you look at the difference here between the initial disqualification of the 3 fact witness attorneys under 3.7A and then the, on re-argument, the further disqualification of the firm in total under 3.7B, you see the disconnect between applying those 2 rules to cases where a law firm seeks to self-represent in a fee dispute. I'm hard-pressed to find or come up with a scenario in my mind where the former client would not be able to meet this extremely low burden that Swarmville is claiming 3.7B establishes. The bar is so low as to essentially be no bar at all, and disqualification would essentially be automatic. And if that was...
Does it matter that we are viewing this section in the context of civil litigation as opposed to a grievance matter?
I don't believe so, Your Honor. I did not see any reference to cases where that would be result in a different application of the rule. There's also some case law where the predecessor rule, I believe it's DR 5-102A, there's case law on the predecessor rule that says that 3.7, or in that instance 5-102A does not apply where attorneys are litigants. And that's the old Saratoga case, 19 AD 3rd 823, citing Walker and Valley 123 AD 2nd 256.
Well, the burden to disqualify someone from picking their own attorney, there has to be a clear showing that the firm disqualification is required. You say that has not been met here.
I submit that it is not, Judge. Again, the 4 instances of prejudice are, I would say, highly speculative, and
they don't outweigh the right to choose your own attorney.
They do not, Judge. And if I can just cite to some language from Swarmville's brief, page 19 of their brief, they claim, and this quote, their testimony can only be viewed as prejudicial. And they're referring to the testimony of the 3 attorneys that were disqualified as fact witnesses. If that's the case, Judge, then I would question why a summary judgment motion hasn't been made, why on their initial motion to dismiss, where all of these 4 prejudicial items were initially brought out, why Judge Nowak allowed the case to continue, why he allowed cause of action for breach of contract, quantum merit, and unjust enrichment to continue. All of these facts were available on that motion to dismiss. These are not new facts that were obtained in discovery later on in the process. So
it actually seems that some of Mr. Hogan's testimony would be favorable as opposed to being prejudicial.
I would agree with that, Your Honor. Again, it's how do we define prejudicial? I think Swarmville would want it to be defined on this very low...
Well, and it's not just how do we define prejudicial, it's how do we define apparent prejudice in the rule.
I would argue, Judge, that the language from Bodkin, that so adverse language, would lead me to believe that prejudicial, as it's used in 3.7b, would be something closer to synonymous with fatal, and that's simply not the case. I would agree that some of the...
That's pretty extreme. The term fatal sounds pretty extreme to me.
Well, perhaps it's somewhere in the middle, Your Honor, but certainly not such a low bar as to be, as I say, non-existent.
Like, it seems to me your point is it has to be something more than it may or may not be prejudicial. Like, it's got to be more likely to be prejudicial. Like, you got to be able to tip the scales, perhaps.
And I believe that that's the language from the Murray case, that the likelihood is substantial as well. And Judge Nowak, again, on the initial motion to dismiss, went through several of these factual assertions that are, were framing as the prejudicial items. And the first being that Mr. Hogan stated, we're done, go get another attorney. Judge Nowak, in discussions during the motion to dismiss, went through that and said, well, that doesn't necessarily defeat the law firm's entitlement to fees. You can tell your client that, look, we're done, I have to withdraw, and what happened here in the interim is...
Because their position is that there was an irretrievable breakdown of the relationship, right?
I think that is the basis, Judge. And that would be the basis for withdrawal.
So that testimony actually would support that
Yes.
position in the underlying lawsuit.
Yes.
Counsel, did Justice Nowak go through the analysis, the balancing, before he decided this motion relative, not to the prejudicial, but relative to Hogan and Wilkes' right in the interest of them being able to select their own counsel? Was that balancing done?
I don't believe it was done to the extent that I think the case would require, Judge. I think on the initial disqualification, the rationale for disqualifying the 3 fact witness attorneys was the concept of jury confusion, and he actually addressed the issue of prejudice and said that he didn't think that there was a showing that the prejudicial items will be prejudicial.
But their disqualification is not an issue before us. Really, the disqualification we're talking about is the disqualification of the entire firm.
Correct. And I don't think that the judge weighed, again, the heavy burden that should be required of the movement and disqualification motion, especially in an imputation motion. 3.7b, the cases have recognized that that's subject to abuse and an even higher burden imputation cases as opposed to the witness advocate 3.7a cases. And I don't think the balancing was done to the extent that it would be required, given the fact that I believe the transcript essentially gives us, for lack of a better phraseology, there may be prejudice here, and so he'll grant the motion. I don't think that they met that burden to show this, again, from Bodkin, this so adverse prejudice.
Good. Thank you, Counsel.
Thank you.
Good morning, may it please the court, Charlie Roberts for the Swarmville Fire Company.
I'm going to start off with a follow-up to Judge Whalen's question. It doesn't seem that Judge Nowak gave any sort of consideration to the plaintiff's right to choose its own counsel, as he was required to do. And I know that's kind of the second step after considering the prejudice argument, but you agree that in the context of litigation, that the rule is not supposed to be mechanically applied, and it seems that he did mechanically apply it here.
Your Honor, I believe that Judge Nowak did go through that analysis. The right to choose counsel was a main part of their argument. He was very deliberate in his decision-making process here. As you know, there was the original motion and then a motion to re-argue on this point. And so, while I don't know if it's stated in his decision or in the transcript, I believe our transcript on this was off the record, but in my opinion, he did go through this analysis thoroughly. And the point that he was hung up on initially was the maybe prejudicial point, but I don't want to stop your question.
But that seemed to be the basis of the reversal of his original decision. That he thought, well, it may be prejudicial, so that's kind of the end game. That's the end of the story. And they seem to view the testimony as if it may or may not. So, he didn't seem to require any sort of tipping of the scales. His bar seemed to be pretty low in the evaluation of the potential testimony.
I apologize.
No, that's okay. It was kind of verbose question to start with.
The rule does say may be prejudicial. And so the text of the rule is may be prejudicial. I argued to the court here that regardless of the standard, these statements are absolutely prejudicial to Hogan Willig. Mr. Hogan stood up in a meeting with the board of directors of the fire company and essentially lost his temper and was tired of hearing questions about when the case is ready for trial, why is this costing so much, And he said, you know, they said, this is taxpayer money. He said, I don't care about taxpayer money, it's my money. And then he said, quote, we're done, go get another law firm.
But isn't that whole exchange consistent with their position in the lawsuit, that there was an irretrievable breakdown of the relationship?
It's consistent with their position in the lawsuit, but I disagree with that. Because this irretrievable breakdown, they started this as a constructive termination.
Of course you disagree with that, that's why there's a lawsuit.
Right. No, but I'll explain, Your Honor. I mean, they are the attorneys. They are obligated to their client to litigate this case the best they can. They have to be good advocates, they have to act in good faith. There are cases, and I don't know that this issue is briefed on this, it was briefed on the motion to dismiss, where a client asking a lawyer difficult questions, why this has cost us $300,000, why has it been 9 years, and when are we going to get to trial? Those questions are fair game. Those are permissible questions for a client. And a lawyer has to answer those questions. They can't just throw up their hands and leave and say, we're done. And in a circumstance where there may be a breakdown, the lawyer has the obligation to go to court to withdraw that. And say, Your Honor, we have this difference with our client, we cannot continue to represent them. And then the judge at that moment at the trial court can look at that issue. And the reason they didn't do that here is because they knew this contingency fee would be at stake then, in front of the trial judge, and the judge would have said, fine, you can go, you're no fees, under the cases where you quit and you waive the contingency fee.
So, you know, we're not here to decide the merits of that issue. We're here to decide, you know, whether this conduct, and whether his statements meet kind of the threshold of apparent prejudice. And it seems that the case law sets a bar that's higher than what Judge Nowak set. As you heard in your opponent's argument, the case law says that the testimony, it has to be more than speculative that this testimony will be prejudicial. It's not just, you know, I know that it does say may, but the phrase is that it's apparent that it may be prejudicial. So it does seem that the bar is a little higher. And then when you couple that with the client's right to choose their own counsel, and here the client is a lawyer, so they choose their counsel at their own, you know, at their own risk.
Well, I think the cases that talk about the speculation of the testimony are where the parties are trying to guess what the testimony might be. And here, we don't have to guess. It's in affidavits, it's in letters, there's an audio recording. Mr. Hogan does not deny that he said, we're done, go get another law firm. He doesn't deny that he said the case was ready, 40% ready for trial. So at the moment that he quits, 40%.
So it sounds like you probably have a winner on that issue, but we're not deciding that issue. We're deciding whether the firm has the right to represent itself in this action. And it's your burden to show that the disqualification is required. You believe you met required, and it's a clear burden.
Yes. And Your Honor, if I may, it's because those statements that they made are prejudicial to their claim for a full contingency fee. Take the 40% ready for trial.
So you want to protect them from prejudice?
It's prejudicial to them. That's the rule. Is it prejudice the client, which
They don't feel that way, but you want to protect Hogan and Lilly from prejudice.
I most definitely do not want to protect them. I'm arguing the rules that we're given. The 40% point I said it goes to the fee. The other point is that the fire company has asserted a number of counterclaims seeking to set aside this hybrid retainer, that it results in excessive fee, that the terms are ambiguous. Diane Timber.
Those all go to the merit, not the issue that's in front of us.
Right, but they were, under this court's decision in Zagari, they were active participants in that transaction. And that makes them and their firm, and again, we're talking about the firm and the right to choose counsel. I'll just point out that they are a corporation, so corporations can't proceed pro se, which is what they've argued. And Mr. Hogan has made clear in his affidavits to the court that he controls this firm. He owns it. He said he is essentially the plaintiff. And unless you have any other questions, thank you.
Counsel. Case 597, Washington Livingston versus Papura. Proceed, counsel.
Yes, morning, Your Honors. John Collins on behalf of plaintiff appellant Corey Washington Livingston, whose position on this appeal, as the court is aware, is that the trial court erred in granting defendant's motion for summary judgment in this motor vehicle accident case upon the ground that, as a matter of law, plaintiff did not sustain a serious injury. There are, in fact, I submit, three triable issues of fact under three serious injury categories: significant limitation, permanent consequential, and the 90/180 days. It's well.
So does plaintiff's expert opine on these three prior rear-end motor vehicle accidents and the workers' comp injury not causing the need for surgery? Or does the doctor just say, as of this date, surgery was required without giving a basis as to why the surgery was required?
Well, two responses to that. First of all, I think Dr. Hamill did state that plaintiff had no prior neck problems.
Which is not true.
Oh, well, she had some neck problems as a result of a 2011 accident, but they resolved. And I think the bigger issue and the more significant response to Your Honor's question is that in moving for summary judgment in a case where the defendant's position is that plaintiff had pre-existing or degenerative conditions in a spinal area.
Well, it wasn't just 2011. There was an accident in December of 2003, a rear-end collision, where there was litigation and it was settled. There was an accident in April of 2004, which was a second rear-end collision, and she was totally disabled for a period thereafter. There was the accident in June of 2010, where she was injured at work and totally disabled thereafter and never went back to work.
And that related.
Then there was the 2011 accident, where the third one prior to this was the fourth accident, and I did not see that Dr. Hamill said he looked at any of those records or that he didn't believe any of those had anything to do with the need for surgery in 2018. Did I miss that?
Well, I think, as I was saying, the more immediate issue is that in stating Dr. Lyso, the defense medical examiner, in stating that everything emanated from this pre-existing or degenerative conditions, had an obligation under this court's March 2022 decision in Shaw versus Nowakowski to account for the fact that plaintiff had no prior complaints of pain. Now, she did, as a result of these accidents in 2000, or the early 2000, 2011, have some cervical problems, but in the 5-year period, the almost 5-year period from 2011 through this accident in 2016, all of her complaints, the records show, related to her lumbar condition. That's why she was disabled. That's why she was getting a workers' compensation award for falling out of the chair, a lumbar problem. That's why she got Social Security disability.
Did Dr. Hamill ever look at the medical records?
I believe that Dr. Hamill implicitly looked at them because he referred to, her prior, noted that her symptoms were likely the result of an exacerbation or activation of an underlying condition. In stating that, he obviously was aware that she had what showed up on films as, an underlying condition, osteophytes and, some, disc problems. But the significant issue, I think, is that It was not causing her pain. It was not until this accident causing her ongoing disability or range of motion losses. And Dr. Lyso never addressed the fact that she didn't have pain. He alluded to these records during the 5-year period, but all of those records that he cited.
Dr. Pearson agreed that the prior films, which he did look at, said there's no difference between the prior films and the post-accident 2016 films, and that the same osteophyte condition identified by Dr. Hamill as requiring the surgery pre-existed the most recent accident.
Well, the critical issue is not that that was there, because we don't dispute that there was a pre-existing condition shown on films under Shah. The critical issue is that she had, quote, no complaints of pain prior to the accident. The pain complaints related
Yeah, and
to...
then, Mr. Scott, just so I can understand, and there were complaints, and correct me if I'm wrong, I may have this wrong, but there were complaints of lumbar injuries, that's where she got the disability from. But there were also complaints, some complaints of neck injury and pain emanating from the prior medicals, right? But you're saying, yes, that's true. However, there was a gap in time between when this neck pain was registered in the records and when this current accident happened. So to say that when she reports that she had no prior neck pain, that's not really accurate, right? Because she did. You're really saying there was nothing in the last few years of neck pain, therefore essentially it resolved. And so when she answers that question, she's answering that question to say, I don't have prior neck pain before the accident because I wasn't experiencing neck pain. Do I understand your position?
Yes, for approximately 4.5 years. She did have some...
Which is a lengthy period of time to go without neck pain, right? That's your point.
Yes, that's our point, is that, and then suddenly, no one, the records indicate, no doctor was suggesting an ACDF surgery for any reason, prior to this 2016 accident.
But your expert, though, in this case, never did look at the prior medicals that did refer to the prior neck pain. So there's no ability for your doctor to opine on whether or not the current injury is somewhat related to the past neck pain injury, or there was even an aggravation of a circumstance.
Well, I think, as I said, I think he implicitly looked at that by saying that her symptoms were likely the result of an exacerbation of a pre-existing condition. So he knew, yes, she's got this condition, but there is, nothing in the record to indicate that she was in pain for, at least 4.5 years prior to this accident. And Dr. Lyso, the defense doctor, states that plaintiff, quote, had surgery not because of myelopathy or radiculopathy, but primarily because of neck pain. So the neck pain arose as a result of this accident. Dr. Lyso never explained why in the 4.5-year period there was no complaints of pain in any of the records that he cited. It's always, pain, lumbar, disability, lumbar. She was not disabled. There was no discussion of a need for surgery. Then following this accident, she's unquestionably in pain. I think Dr. Hamill linked that pain to the accident, saying that there was an aggravation of this essentially, dormant or, at least, non-active condition. And thereafter, Dr. Capicato said, you really should get surgery. She got a second opinion. Dr. Hamill said, you really should get surgery. And up until that surgery, she had, range of motion losses that were recorded during the course of her treatment by a physical therapist, and they never really resolved until after the surgery. And then following the surgery, and as a result thereof, she has dysphagia, permanent swallowing problems that are, undisputed by Dr. Lyso or any other element of the record. So I think, a trier of fact would find that all of this arose and the surgery was necessitated strictly by the motor vehicle accident, that caused the pain, that necessitated the surgery, irrespective of
You
any
should be mindful of your
pre-existing
time,
condition.
Mr. Collins.
And for that reason, I submit, that there is a question of factor on the serious injury.
Very good. Thank you for counsel.
Good morning, Your Honors. My name is Stephanie Messina. I'm with the firm Bergio, Curvin and Banker. I represent the defendant respondents per pura with regard to this action, and may it please the court, I'd like to start by addressing Justice Niemoyer's question. No, Dr. Hamill was not afforded the opportunity to review the records dating back to 2003. No, he was not afforded the opportunity to review previous cervical MRIs and compare them to post-MVA MRIs, of which there are many. There are 2 in 2004 for the cervical spine. There is one in 2011. There is another in 2016. Plaintiff herself did not know whether she could correlate the need for surgery and this injury to the subject accident.
Dr. Hamill's opinion was that the plaintiff needed surgery in 2018 when he performed it.
Correct.
He did not opine as to what was the cause or what necessitated that surgery.
Correct.
And you're saying it can't be just the 2016 accident, since he never looked at the records from 2003, 2004, and the prior accidents. So therefore, his opinion as to the need for surgery might be true that she needed surgery, but no causation.
Exactly. Our opinion is that plaintiffs have not met their burden of proof in showing that there is a question of fact by not giving Dr. Hamill that full picture.
Did the burden shift? I think your opponent made reference to Dr. Lifeso not mentioning or explaining how the pain that the plaintiff was experiencing after this accident was there, yet prior to the accident, there was 4 years of no neck pain. Doesn't that have to be explained in the expert's affidavit on your behalf before the burden shifts to plaintiff?
It does. So firstly, our position is the burden did shift because Dr. Lifeso examines not only the plaintiff herself, but he examines both her prior and subsequent MVA records. He examines her before and after diagnostic imaging, and he examines, as I said, the plaintiff herself and takes a history wherein she herself tries to minimize her symptoms, but herself does not even say with certainty, yes, I believe my injuries are from this accident. We believe the burden also shifted because we had Dr. Kenneth Pearson do a before and after comparison of the MRI films where he says the pathology, specifically the pathology at C4 to 6, is essentially the same.
Well, sometimes the films, both before and after, when you have them, you don't always have them, of course, but in this case, because of the prior accidents, we have them. The films look the same, but just because you're looking at these indications of a deviation from a normal spine, and they're both present both before and after the accident, and they look the same, things haven't changed. Yet, there may be nerve complications that happen after an accident that are not going to necessarily show up on there. We've got complaints of pain. Your opponent is saying they're never explained away. So how is it that Dr. Lifeso's report doesn't explain away the pain that's being reported by the plaintiff after this accident that brings us here today? He doesn't say, well, here's the reason why she's experiencing pain. He simply says that it was short-term, temporary, and it would resolve.
Mm-hmm. Dr. Lifeso does say he believes it's a temporary activation and a temporary result of the degenerative process that was pre-existing prior to the subject accident. And therein is where we feel defendant respondents have met their burden in proffering that evidence that Dr. Lifeso's position is that this was a natural consequence of the degeneration already present in plaintiff's spine. We also, primarily because her lumbar spine was her...
Isn't that an aggravation of a pre-existing condition, though?
The issue...
If in fact there is pain, there wasn't pain before the accident, there was a condition before the accident, there's now pain after the accident, there's an aggravation of a pre-existing condition, which causes the pain.
Not necessarily, Your Honor. Plaintiff has been complaining of neck pain prior to this accident since 2003. She had 2 accidents in 03
Your
and
opponent says
04.
not for 4 years plus maybe before the accident. That's a long time to be going without neck pain. And how far back do you go to say, you know, this neck pain, you complained of neck pain 10 years ago. So therefore, you know, this is a neck problem that's pre-existing.
I would point to plaintiff is on considerable pain medication prior to our accident. She is complaining of pain. She does have range of motion losses that predate the accident of her cervical spine. And those are compared by by Dr. Lifeso in his affirmation, stating that the range of motion losses are not changed, that the range of motion losses of both the cervical and lumbar spine are not changed from this accident and predated the subject accident with a lengthy history.
Dr. Lifeso says the comparison between pre and post-accident MRI show that there's no change.
Correct.
And that based upon the records from the thing, he believes, yes, there could be a temporary exacerbation, but it would have resolved in 1 to 6 weeks after the accident. And nobody responds otherwise. Is that correct?
That's correct.
Anything further, counsel?
Your Honors, I submit to this court, we defendant respondents have met the criteria required that this court has set forth in Barasco, Overhoff, Roger v. Seuss, and most recently in Stroh versus Cromer. Defendant respondents have met their burden, and in response, plaintiff appellant has not provided this court with objective evidence of injury to sustain a question of fact and to show a serious injury to this court. And I would ask this court to affirm the lower court's order dismissing the plaintiff's complaint.
Thank you, counsel.
Thank you.
Case 598, Main Street America Assurance versus Merchants Mutual Insurance Company.
Morning, Your Honors. Steve Piper on behalf of Phillips Fine, here for Merchants Mutual as the appellant. This is an additional insured case, and while we have a 330-page record, we would submit that about 5 pages of the record really matter to answer the court's question here, which is ultimately, does XL Specialty, are they entitled to a defense, or have they proffered enough evidence to this court that they qualify as an additional insured and therefore are entitled to a defense in the case involving Mr. O'Connor? We maintain they didn't. And the reality is, well, it's 5 pages in the record, it's 34 paragraphs in the complaint, and it really boils down to about 3 paragraphs in the complaint, 18 through 20, which identify what happened to the extent it's pleaded. What's missing is any involvement of Mr. O'Connor, any proximate cause of Mr. O'Connor.
So the complaint alleges he fell off a ladder. It alleges labor law causes of action under 240, 241-6, and 200. So when I read that kind of a complaint, isn't it kind of logical to question whether he may have contributed to the happening of his accident?
It's a fair question to question that, Judge, and I'll harken back to something you mentioned earlier. You used the term mechanical application on an earlier appeal today. And what we have here is a mechanical application where you start with the complaint. And the complaint, unless it explicitly identifies a cause of action or a proximate causation, it doesn't trigger the duty to defend.
Who chose to use the ladder? Mr. O'Connor is a single operator, isn't he?
Judge, we don't know the answer to that question. And that, again, is the point, right? We don't know.
We do know that Mr. O'Connor is a single operator. As I understood it, he was retained and he's the one who was injured.
That is true. But that puts the focus on Mr. O'Connor's actions that day.
And if he chose the wrong equipment to use, and it was his choice as the single operator, he's the supervisor, and if he picked the wrong equipment, isn't that contributory negligence, perhaps? and that goes to 241-6.
It's not contributory negligence as pleaded, right? The reality is, the claim here is that the defendants, not Mr. O'Connor,
No question.
the
No question
defendants
about that. You're-
improperly selected the complaint. Look, if he did, then XL Specialty very easily could have answered that question, so that I don't have to answer it and you don't have to raise it, Judge. All they had to do, they defended this case for a year before they started the declaratory judgment action. All they had to do was answer the question. That Mr. O'Connor selected the equipment. It was his equipment. He misused it. Anything that they would have said along those lines triggers a duty to defend. There's no argument here that XL Specialty qualifies, but for the fact they don't actually answer the operative question. And so what the Court of Appeals tells us...
They don't answer the operative question when? Before the complaint was filed, you're saying?
At any point. This record says nothing as to the scaffold, the Baker scaffolding issue. It says nothing as to what the proximate cause of the incident was. It doesn't even raise the question of the proximate cause.
Is it enough that that there can be an inference from the complaint that the plaintiff may have contributed to his accident? Is that enough to trigger the duty to defend?
Your Honor, I'm not aware of any case in New York that's addressed this issue that says you can infer causation in a complaint. The reality is a carrier is stuck with the allegations in the complaint, and we have to apply those as if they're pleaded as true, whether groundless, false, or fraudulent. The same holds true when analyzing the complaint. What is the complaint? What's the explicit version of the complaint? What does it say? And we have to mechanically apply those. If it doesn't answer the question, then the plaintiff, the party seeking coverage, has the opportunity to supplement that record via extrinsic evidence, and they elected not to do so here. The only thing they submitted was the complaint and make that very argument. If I can, let me cast it in the terms of the Burlington case, which really controls here, right? Burlington versus New York City Transit, 2018 Court of Appeals case. In that case, there are certainly allegations in that complaint which you could infer the operator of the excavator, which hits the electric line in the subway system, had something to do with the accident. You could certainly infer that, but what does the Court of Appeals say? That's not enough anymore. Simply being there, but for the fact that he was on the scaffold, but for that he was doing work, that is insufficient to trigger the duty to defend and or indemnify. So if you start inferring what the complaint says, it leads to inconsistent results. That's why we have a mechanical application. So by way of Burlington, let's say the inference is that it was in fact the person on the excavator's fault in Burlington. The facts ultimately say that's not what happened, right? What happened was, while he was operating the excavator, he was operating, the negligence, the proximate cause of the issue was someone else. That's the same situation here.
But the complaint here also does, as I think Judge Nemoyer pointed out, the complaint also does allege that he was a self-employed subcontractor.
Of course.
So can't it be inferred that it was his equipment, he placed it, and then he fell?
What if it wasn't, Judge? What if, let me answer your question.
Doesn't that then go to indemnification? I mean, we're talking only about the duty to defend here.
The duty to defend, again, driven by the allegations in the complaint,
right,
is tied to what is explicitly stated, not what is inferred by the allegations of the complaint. If it's not explicitly clear.
The duty to defend far broader than the duty to indemnify.
Of course.
And if there's a possibility that it could be, you do the defense and then you win and you're not having to indemnify. I thought it's a broad issue. And here you're saying, oh no, they have to specifically make the allegations rather than broad scope under the complaint.
And the reason I'm saying that is that's exactly what the Court of Appeals tells us to do, because the reality is you have the opportunity as the party seeking coverage to fix that issue by adding additional things. This court issued an opinion in Pioneer School District, which went through a full record and found there wasn't an approximate cause. The same analysis applied there, right? If we had a full record here and we knew exactly what happened, then we'd be able to answer these questions. But as it is, we got 3 paragraphs that say he was standing on a Baker scaffold. So, Your Honor, what if, we don't know this because it's not on the record, but what if the reality is that Baker scaffold is owned by XL? It was put together by XL, and the reason it failed is because, we don't even know why it failed, it's not on the record, but the reason it failed was XL. Would we say on that record that O'Connor is the proximate cause of this accident? I would submit we wouldn't if we followed Burlington. The reality is, if that's not in the record...
We don't know that yet.
Well, that's exactly the point.
And the question is there a duty to defend at this point or not? Not, is there a duty to indemnify in the end? And your attitude is the complaint must be so specific to exercise the duty to defend.
Otherwise, we're taking, just because he is in the action, that therefore his actions are ultimately inferred to be a proximate cause, and that is a leap beyond, I think, what the established law is.
Counsel, you should begin to wrap up.
Right. Well, my final point, very briefly, there are 2 other issues here that we haven't touched on. One is Insurance Law 3420D2 and the application of principles of estoppel. I think very quickly we can work through both of those. The reality is this is a fundamental issue of coverage, so 3420D2 does not apply. I don't think that's really heavily argued. And it's been a law for decades that there has to be some level of prejudice here. Merchants took its position, disclaimed coverage within a month of the suit being filed. There's no indication that XL Specialty lost an opportunity to defend this case, and in fact they have been defended throughout the case. There's no prejudice here. We would submit this is really an up and down decision on what actually is in the complaint, whether or not, to Your Honor's point, that's sufficient to trigger a defense obligation.
We have that argument. Thank you, Counsel.
Thanks, Judge.
Good morning. May it please the court, Karen Felter from the Smith-Sovic office on behalf of XL Construction and Geiger. I would just like to start with the allegations of the complaint, which Merchants Insured actually drafted. He alleged that he fell off the baker's rack in the complaint, and that, of course, implicates a very similar case, which is the Kalmar case that we cited in our brief. And there, in the underlying action, the personal injury suffered by an Arcadia employee said he lost his footing on a stairway while working on a construction project, and the court said that those allegations indicated that the injury resulted at least in part from the acts or omissions of the Arcadia employee while performing his work, i.e. his loss of footing while on the stairway, regardless of whether the Arcadia employee was negligent or otherwise at fault for his mishap. And I would submit that that is exactly the situation that we have here. O'Connor fell off the baker's scaffold. He alleges that the defendants did not, the exact language that he uses is that the defendants did not utilize the proper necessary safety devices under 241, implicitly alleging that he was not using or wearing one at the time of his fall. So I think that the Kalmar case suggests that under these facts alleged in the complaint, that the acts or omissions of the employee can trigger AI coverage. The second thing...
well, your opponent, I guess the question is whether the complaint needed to say more than he fell off of a baker's scaffold. Whether it needed to say, for example, it was my scaffold, I brought the equipment, I set it up. That clearly would have indicated that he may have been partially at fault for the happening of his accident.
Well, I mean, even if it wasn't his scaffold, the point is that he's alleging that the proper safety devices were not used. So if he was not using a proper safety device, the facts of the complaint can, I mean, and certainly as Your Honor pointed out, the complaint does allege that he was the sole...
he was a self-employed
correct.
subcontractor.
So, I mean, if he's using a baker's scaffold and he fell off of it and he's doing he's alleging to be in the complaint that he's doing the contractor work on the job, then you can assume or imply that it's certainly implied that if he's not using a device, that he wasn't wearing one or using one at the time. So his failure to use a device.
So your attitude is at the early stage of a complaint, it should be read broadly and it should be included in the fact that he could be contributory negligent.
Yeah, it's also possible that he could be solely contributorily, he could be the sole proximate cause based on his choice not to use a device.
The duty to defend is broader than the duty to indemnify, whether indemnification happens or not.
Correct.
You were entitled to a defense.
And the Burlington case, contrary to my opposing counsel's arguments, has nothing to do with the issue of the duty to defend. In fact, in that case, the Burlington actually picked up the defense. So the sole issue in that case was the question of indemnification. And the cases had exclusively had resolved around the issue of indemnification. So if courts were required to do an entire analysis and complete a factual record before the issue of the duty to defend was resolved, it would undermine the entire body of case law on the issue of the broad duty to defend that's been developed in New York over a number of decades.
Pay for additional insurance.
Exactly. So
Anything further, counsel?
No.
Thank you. Case 600, Elford versus Katz. Are you the case?
Oh, yeah.
Proceed, counsel.
Good morning, Your Honors, and may it please the court. I'm Mr. Zdarsky, Joseph Zdarsky. I represent the appellant. In this case, it's a little bit of a peculiar case because the decision and order that it is appealed from was actually written for two cases, both the malpractice case, which we're on appeal on here, as well as the underlying case, which was a breach of contract case against the estate. I represent the estate in an action against the lawyer who prepared the documents for the 2017 estate plan, which turned out to be insufficient and resulted in...
Well, Counsel, we're familiar with the facts. Doesn't this really boil down to a very narrow issue raised? It was a motion to dismiss because, in essence, it was premature.
Yes.
Because the damages were speculative. Well, let me ask you this question, and I'll ask your opposing counsel this. When the motion was made, that may be true, correct?
It may be true. I would contend not, but I would say yes, it may be, but...
But as you pointed out, once the court made a decision on the first motion that found that the Q-Tip trust had to be funded, once the court made that decision, does that not change the ultimate interpretation of the facts before the court?
Well, I think what it did is it created a definite loss to the estate for the breach of contract and satisfied the requirement that we show actual pecuniary loss.
So whether you had it prior to, and assuming for this argument you didn't have it, that question was answered once the court granted the motion.
That's correct. That's essentially the basis of our appeal. There are other subsidiary issues. We did supplement the record to provide documents for the court to show that after we filed the appeal, the underlying action was settled, and we wanted that information before the court, and you got that. But that's essentially all. What I would like to make as our point on this appeal. I think it should be reversed, and we should go back to have discovery.
Thank you, counsel.
Thank you.
May it please the court, PG4R on behalf of the respondents. Your Honor, I'd like to go right back to your question about whether or not there's been damage. And the motion was made on the basis that at the time the motion was made, the estate had not been damaged and may never be damaged. The judge's decision held that the estate had not been damaged. The 2017 will prepared by Mr. Katz on behalf of the respondent, the court found that it was consistent with the decedent's express wishes.
But Counselor, see, this is where I think I part ways with you. I don't disagree that based upon the Q-tip trust, the way it was drafted in the prenuptial, based upon the way the will was drafted, that those two things may be appropriate. The allegations are here is the attorney failed to obtain any type of for lack of a better word, a waiver of the Q-tip trust that's going to affect the ultimate estate. And the argument that you raised down below, when I looked at the papers, was very narrow in a sense of you were looking to say, hey, damages are speculative. There's no damage. They can't prove any damages. And I think, quite frankly, at that point, I agree with the position you had. But once the court ruled that the estate had to pay into the Q-tip, whether it's binding or whatever the court had found, the whole issue was damages. And at that point, why isn't that not, it's no longer speculative, they had to pay that because of the attorney's, quote unquote, let's just say, failure to obtain the proper release that he needed?
Because, Your Honor, the estate itself has never been damaged. We are here essentially because the appellant and her siblings, as beneficiaries of that estate, are upset that they did not receive as much from the estate as they thought they were going to. The corpus of the estate has never been depleted, not like the Finneman case, Your Honor, where the attorney gave bad tax advice, so the corpus was reduced. The corpus of this estate has never been reduced. And under Finneman, a beneficiary who's not in privity with the attorney cannot maintain an action because they did not receive what they thought they should have received in the estate. The court, in this case below, looked at these two allegations. The first one was that somehow that the 2017 will was inconsistent with what Dr. Genko wanted as his estate planning. The court below, and I will assert, Your Honor, they are now collaterally stopped because they never appealed that decision.
Well, collateral stop was not before us. I looked at that carefully. I didn't see it raised below.
That's correct, Your Honor.
Okay, so, I mean, so that's not before us right now.
But the estate raised it. And the issue was decided against them that, one, that there was nothing showing that the 2017 will by Dr. Genko was in any way inconsistent with his expressed desires. And secondly, there was no consideration of any oral modification of that 2006 prenuptial agreement.
Isn't that something, and I asked this question, something further on down the road, if it's ultimately determined that that was his wishes, then there's been no damages, but if it comes about that it wasn't his wishes, and the agreement was to provide these documents, and was to provide a waiver, how is that not relevant?
Because, Your Honor, it's already been decided that in the estate litigation, the court has already decided that they were consistent with his expressed desires. The court has already found that it's not inconsistent with the 2006 prenuptial agreement. But in any event, Your Honor, even if they go down that line and find it, there is no evidence, and nor can there be, that the estate itself has or can be damaged. There's no allegation that the corpus was reduced. The only allegation we have here is from the appellant, who's a beneficiary of that estate, that she did not receive as much as she thought she should have gotten, or her siblings. But the estate itself has never been damaged, Your Honor.
Very good. We'll take a look at that, counsel. Anything further?
Nothing, Your Honor. Thank you.
Case 601, Walker versus Erie Insurance Company.
Thank you. May it please the court, Dan Cohen on behalf of the appellant. Juanita Walker filed a lawsuit against Peter Nails in 2019, and I draw the court's attention to her complaint. The factual allegations start at page 11 of the complaint, record 134. She claims that she came into the Peter Nail salon for a pedicure. The defendants were negligent because they failed to properly clean, disinfect, sanitize the pedicure equipment.
During the course of the procedure, she came down with an infection.
That's the claim. That's the only claim. She claims that the equipment was dirty, the bath was dirty, everything was dirty, and she got MRSA as a result of the pedicure.
Because she was there getting a pedicure.
That's the only reason she got it, Your Honor. There's no other question about the fact that that's when that's her claim. She didn't claim that there was a problem with the premises. She claimed exclusively, solely, entirely that she went in for the pedicure, the equipment was dirty, that was used on her, her cuticles were cut too small, she bled, and she was caused to suffer MRSA. Nobody questions that the pedicure is a professional activity. We have an exclusion in the policy that says the insurance does not apply to bodily injury due to the rendering or failure to render cosmetic, ear piercing, tonsorial, physiotherapy, chiropody, hearing aid, optical, or ophthalmological services or treatments. No one argues the fact that this isn't a cosmetic procedure.
There's no injury to the plaintiff unless the equipment is applied by one of the technicians onto the body of the plaintiff, right?
That's it, Your Honor.
That has to take place, and the fact that the equipment isn't clean when it's being used is the cause of it. Your argument is that that has nothing to do with the premise liability.
Exactly right, and there was no claim of premises liability until she proved up her default years later and threw the word premises into the judgment.
Right.
That's the argument. Whether you use the term due to, arising out of, cause, any term you want to use, any term you want to use, this accident was due to, arose from, was caused by the pedicure, the use of the dirty equipment on her nails, on her feet, and the exclusion applies.
What about the position of the notice of exclusion?
The policy, Your Honor, this isn't a notice of cancellation case, Your Honor. And I suggest to you that the case law is clear. The policy is before the court. The policy is what the court has to consider. There's no question what the policy contains. There's no requirement that hasn't been met.
She said she didn't get that exclusion language.
That's what she says.
It was but that was in the complaint. It was alleged in the complaint that she didn't receive that the policy she received did not include the exclusions.
That's what she alleges, Your Honor. But the policy is the policy that the plaintiff put into the record. It is a certified policy in this case. The policy includes the inclusions. The policy includes the exclusions. There is no case law that supports this contention that, well, if she claims that she didn't receive the exclusion, it doesn't apply. There is no case law that says that.
But so I guess the question is whether you as the movement had to show proof of mailing.
And I say we don't, Your Honor. I say there's no obligation to show proof of mailing. The policy is the policy. Think of how many times this court has looked at insurance policies, certified copies of insurance policies, presented to the court without any proof of mailing, without any proof that the policy was sent. There is no obligation.
That may be true, but here the complaint contained an allegation that the policy she received was not complete.
But that doesn't change the fact that the policy is what the policy is. The court has...
No, but the question is whether she was on notice of the exclusion, right?
That's her contention, Your Honor. But the policy, there is no case law that suggests to this court that if you can't prove that you sent a copy of the full policy to the policy holder, it doesn't count. The court has to...
So the position is if there's a certified copy of the policy in the record, we just that's proof that that's what controls this action?
Exactly, Your Honor. That's exactly the rule, and there's no case to the contrary. Again, this is not a cancellation case. We have to prove that a cancellation was mailed. It's not a case where you have to, there's nothing in the insurance law.
There's no question this is the policy that was signed.
As compared to a cancellation case where the insurance law says you must prove that the policy was sent, cancellation notice was sent on a particular day, in a particular way, at a particular time. There is no requirement in the insurance law for this. There isn't.
So the policy is what it is, and it doesn't matter whether the complete copy of the policy was actually sent to the insured? Because this was the policy that was in place. That's your position?
That's right, Your Honor. And there is no case law to support that position, that if you can't prove that you mailed the complete policy, the policy doesn't count.
Except it is part of the complaint, which is different than most cases.
I understand. Justice Smith, I understand that, but that doesn't make it the law. The fact that she alleges that doesn't mean that because she alleges that, even if it were true,
Well, she doesn't allege that that isn't the policy. She just alleges that she never received that.
Right. But the policy is what this court is considering. The policy is what the court's considering. And there is no case law that suggests that if you can't prove that you sent a particular exclusion or a particular piece of paper to the insured, it isn't part of the policy to be considered by the court.
So, but I understand what you're saying, counsel, but to the extent that there's an argument here that she didn't receive, or she received the policy without the exclusion in it, so she's not on notice of that. In the posture of a motion for summary judgment, aren't we looking at putting forth the proof that, well, this is the policy we sent to her, and here's the, I mean, we go through that proof, as you point out, we go through that proof on cancellation. It's not unusual for the court to get that kind of proof that, look at, this was the policy, the complete policy that was sent, and therefore your burden is carried on, this was included in what we sent.
Sure. Your Honor, the difference is, respectfully, that we have a certified policy, which is a policy that was that the plaintiff alleged was in place at the time. This was a policy, and unlike the cancellation cases where there's a requirement that you demonstrate that you mail something at a particular period of time in a particular way, there isn't the same requirement here. There isn't. The courts look at the certified policy and say, if this is the certified policy, this is the certified policy, and it is. And no one's questioning that. No one's questioning the fact that this is the certified policy. They've never said, this isn't the policy, it's a different policy. No one has alleged that. Yes, she says she didn't get it in the mail. I get that.
You say that doesn't matter.
Doesn't matter. Doesn't matter.
Well, if she's saying that she didn't get an exclusion when she got her policy, isn't the policy that is you're claiming is the certified policy is not the same policy that she received? And so when she's saying the policy I received didn't include the exclusion.
Your Honor, the policy that was presented to the court for consideration in this motion, the only policy that existed, contains the inclusions and the exclusions. That's the policy before the court. That's the only policy before the court. There is no other policy.
I understand.
And no requirement, Your Honor, unlike the cancellation. I don't want to repeat myself.
No, we got the argument, counsel. Thank you.
Thank you.
Good morning. The issue that you were just focused on, whether or not she received a copy of the exclusion, deals with their cross motion for summary judgment. Both parties moved in this case.
Right.
I've given you case law that supports our position that it's the North Country insurance case. That's a Fourth Department case. I think that's directly on point on that issue about whether she received notice of that policy. So I'm going to stick with that, and I'm not going to argue that, okay?
Are you contending the policy did not have the exclusionary language in it?
Yes.
So the policy she paid for, the policy that's before the court with the exclusion in it, is not the policy that she was aware of?
That's what the insured said. Now, you have to remember, I don't represent the insured. I represent an individual who is injured. But the insured told us, now they didn't defend the insured. So, of course, when we sued the insured, we're stuck with dealing with the insured, and that was Jim Verastro that represented her, said we never received this. That's why it's in the complaint. That's why it's a question of fact. That's why their cross motion should be denied. So yes, Your Honor. I want to focus on our motion.
Well, just getting back to that question, you never put in any sort of affidavit from the insured saying that they didn't receive the policy, but you say, not my burden.
Correct.
It's the defendant's burden.
It's their burden. They don't even get to the motion unless they meet that burden, and so they didn't meet it. Now, if they met that burden, we'd have to subpoena her and she'd have to testify. That's why there's a question of fact, and that's why their motion was denied. So now, going back to our motion. The issue on our motion, I think, really boils down to one thing. Whether, in the insurance industry, if you read all these cases, there are two types of professional exclusions. One of which says that an exclusion that is due to the rendering of a cosmetic service or a professional service. There's another provision that's out there that says it excludes injuries arising out of a professional service. There's only two. You could read cases all over the country like I did. Now, my opponent in this case, now our case includes, arguably, I say arguably because she didn't get the exclusion, but even if it existed, what it says is due to. It only excludes injuries due to the rendering of a cosmetic service. Now, my opponent has cited multiple cases where they mix and match that different language, arising from and due to. And the question on appeal for you is, are they the same or do they mean something different? And I'll submit to you, it's a question of first impression in New York State, whether those two professional exclusionary policies mean different things. Both of us have searched cases in New York and they don't exist. I'm going to get to in a moment. I found a case over the weekend from another jurisdiction, but I'm going to get to that in a second. So let's talk about what's not in dispute. A cosmetic procedure, in this case a pedicure. I'll use their definition. A pedicure involves putting your hands and tools on someone's toes. I've never had one, but that's what it is. The argument in our complaint, and the only allegation in our complaint, is that the negligence was the cleaning of the tools in advance. If you look at our complaint, and he says you got to just look at the complaint.
Yeah, but you don't, the fact that the tools may not have been cleaned doesn't matter unless she's getting the pedicure.
And that is...
They don't touch her feet absent
Judge,
a pedicure.
You are exactly correct. If the policy said it excludes injuries arising out of a pedicure, you're absolutely correct. And what I said to the judge below, I said if this policy exclusion said arising from, we lose. We admit that. But it doesn't say that. It says due to the pedicure, due to the rendering of the pedicure. Cleaning those tools in advance is separate. So here, let me tell you about the case that we found over the weekend.
But she wouldn't have been infected if she wasn't getting a pedicure.
True. And he says in their papers, and I can read it to you, he says multiple times, more than 10 times in their briefs, that this injury wouldn't occur but for the pedicure. They say it's a but-for standard, okay? And it always bothered me that I couldn't find a case where some court somewhere compared these two different provisions, right? You've got one that says arising out of and one that says due to. You would think some court had dealt with that. I found one over the weekend. You know how I found it? There's a blog put out by a law firm called Hurwitz Fine. And in that blog, they summarize cases from around the country. And in 2004, they summarized a case called Utica National Insurance, which is down the road, of course, versus American Indemnity Insurance. And in that case, what the Supreme Court of Texas, the highest court in Texas, specifically looked at, do those two exclusions mean the same thing? Does due to mean the same thing as arising out of? So I find the case, I look at the case. Let me tell you the facts of the case just briefly. So in that case, there was an allegation that a hospital it was actually, I think, a private practice, failed to properly store fentanyl, obviously a very serious drug. And because they failed to store it properly, it was injected into someone. That person ended up with hepatitis C. Didn't die from fentanyl, but got hepatitis C. Utica National claimed that the exclusion in that case, which read due to, same as ours, they said the injection of the fentanyl was a professional service, and therefore, but for the professional service, there would be no injury. Sounds exactly like what they're saying in this case, right? The highest court in Texas said that they reject Utica National's but-for interpretation. And I'm reading direct quote now. The policy excludes injury due to the rendition of professional services. The argument that a bodily injury due to professional services requires more than simple cause and fact is supported by other policy exclusions which appear to be drawn more broadly, excluding harm arising out of conduct instead of due to. To us, the different wording in these exclusions is significant. They go on and say, we conclude that the phrases should have different meaning. The Supreme Court of Texas. The most reasonable conclusion is that due to requires a more direct type of causation that could tie the insured's liability to the manner in which the services were performed. We therefore reject Utica's argument that the professional service rendered after the negligent storage event satisfies the exclusionary language. So what they're saying is you have to separate what happens before the professional service from the professional service. The service here is a pedicure. What happened before was cleaning tools. If this policy had the other language arising from, I lose. But it says due to. This case is directly on point. It's the only case I could find in the country, but it's from the highest court of Texas. And you know as well as I what the standard is on an exclusionary clause, right? There's insurance here unless it's excluded. And they have the burden of saying that this due to language can only be interpreted one way. If you can interpret it two different ways, we win. I've got the Supreme Court of Texas. There were 7 judges on that panel who held it is ambiguous. Due to means something different than arising from. And if I've got 7 judges like yourselves who've come to that conclusion, it's obvious that this is either a very narrow exclusion or it's ambiguous. Either way, we win on this argument. Before I just move on, that case, that Utica National, I'm going to give you the site. I'm going to also submit, and I know you have a procedure, within 5 days I'll submit requests to put this in the record, but it's 141 Southwest 3rd, 198. 141 Southwest 3rd, 198. And I'll also give you the site to the Hurwitz and Fine practice pointers, where they specifically say that the insurer relied on a provision in its policy excluding coverage for bodily injury due to the rendering of a professional service. The insurer asserted that this exclusion precluded coverage anytime a patient's medical treatment is a but-for cause, even if the professional service itself was performed with all due care. The court disagreed. Our case, there's nothing in our complaint that says that the pedicure was performed improperly. Nothing. The only thing it says in our complaint is that the preparatory act of cleaning and disinfecting those tools, that's what caused the injury.
You should begin to wrap up, Counsel.
I will, Your Honor. I just want to talk about the one case from New York that is also on point, which is in my notes here, but it's the Wiener versus Lenox Hill case. So this is in our briefs, Judge. It's very similar to that Texas case, except in Wiener versus Lenox Hill, this is the Court of Appeals of New York. They were asked to decide whether a alleged course of conduct was either negligence or medical malpractice. So was it ordinary negligence or was it professional? Very similar idea, right? And in that case, what happened was the hospital failed to screen blood for HIV, and the patient ended up with HIV. The allegation was that was negligence. The hospital came back and said, no, that's professional malpractice because there's codes and regulations about storing blood and collecting blood. The Court of Appeals says, and I'll read it to you, because the challenged conduct was not linked to the medical treatment of a particular patient, we conclude that the claim sounds in negligence. Again, here's the Court of Appeals. By contrast, when the gravamen of the complaint is not negligence in furnishing medical treatment to a patient, but the hospital's failure to fulfill a different duty, the claim sounds in negligence. That's exactly what that Texas case says. So if it's the professional service, the pedicure, that's one thing. But if it's the acts leading up to it, it's different. And in the insurance context, it all matters on the language.
Thank you, Counsel. Case 602 and 603, Allen versus Grimm, MD.
Thank you very much.
Good morning, Your Honors. Taylor Holmes here on behalf of the appellant. I'd like to begin my argument by pointing out the main issue in our case in front of us is that the respondent's expert based his opinion on a misstatement of fact. The respondent submitted an expert affidavit from Dr. Peter Weiss in support of their opposition to our motion for summary judgment. In his affidavit, he refers to a laceration to the common digital nerve to the left finger and ring finger web space. Mr. Weiss based his opinion on an operative report from Dr. Tomeno stating that the laceration was found during exploratory surgery. Nowhere in Dr. Tomeno's operative report does he even refer to a laceration of the nerve. In fact, he actually states verbatim, there was a neuroma in continuity that was really not identifiable as involving any specific fiora, but the technique of following the third common digital and second digital proximally allowed me to dissect away the second common digital and the rest of the median nerve proper. He further goes on to state...
But he did say there was an injury to the median nerve.
He does in fact state an injury, but he does not anywhere state that there was a complete laceration, which means the entire nerve was cut. He
Well,
even
did Dr. Weiss refer to it as a complete laceration in his expert affidavit?
Dr. Weiss
I thought
does
he just
not
used the term laceration.
refer to a complete laceration, but the
He
term...
refers to it as a complete laceration one time and a laceration 4 or 5 times.
Thank you, Judge. He does refer to it as a complete laceration at one point in his affidavit, but the term laceration, when it refers to a nerve, typically means a complete cut. The nerve is such a small facet of the wrist.
And other people believe it just means injury.
Yes.
And he didn't claim, as I understand it, the plaintiff's expert does not claim that it was negligently done by Dr. Grimm.
Yes, that is true, Your Honor.
Okay, and Dr. Grimm doesn't deny or doesn't say that it was pre-existing. He said it might have been pre-existing. He doesn't deny that he might have caused it himself, does he?
No, that is true.
He says it's unreasonable to categorically assume that he caused a neuroma. That doesn't seem enough to get you summary judgment.
I understand, Your Honor, but respectfully, I'd like to say that the laceration and what Dr. Tomeno actually found, a neuroma in continuity, are two completely different things. By definition, a neuroma in continuity is a neuroma that occurs when on an intact nerve.
But 4 doctors did agree that there was some injury to the nerve during the procedure.
Yes, that is true, Your Honor. We are not arguing that Dr. Grimm may or may not have nicked the nerve during the procedure. The argument is as to whether or not the respondent's affidavit is able to support their opposition to our motion for summary judgment.
With respect to the post-operative care.
True.
Because that's all we're
Yes.
talking about here.
Yes, Your Honor. Their expert relies completely on the fact that there was a laceration to the nerve. They do not state anywhere that they may have nicked or caused a minor injury to the respondent. They only mention a laceration. There's nothing to show that...
But he goes through, before he gives his opinions, he goes through kind of what all of the medical records show and describes the records that reference an injury or possible laceration.
Yes, that is true, but the expert does not anywhere in his affidavit make mention to that. He only goes forward in the record to
We're talking about
show...
in his opinions.
Yes,
He
his
doesn't.
opinions. He only goes forward to state his opinion on the fact that Dr. Grimm failed to notice the laceration, failed to properly treat the patient post-surgery, but there's nothing
But
to...
if there was an injury,
Yes.
there's no question that there's a certain golden window of opportunity.
Yes, that is true.
And that the symptomology being described by the plaintiff was different post-surgery than it was pre-surgery, intermittent versus persistent. And that therefore, the opinion of Dr. Weiss is that that should have been enough to check. And Dr. Grimm didn't even see the patient for 3 or 4 weeks after the surgery, when that window to fix the neuroma, if it was caused by the surgery or as a result of the surgery or a consequence of the surgery, even if it wasn't caused, but it just resulted from, that window was blown and that was the negligence in the post-operative treatment.
Yes, Your Honor.
Okay. I just wanted to make sure I understood that was the allegation.
That is true, Your Honor, but that does require some speculation as to whether or not Dr. Grimm should have known that there was an injury that occurred during the operation and whether or not there would have been a difference if the neuroma incontinuity was a result of a laceration or just a nick.
But there
during the
was
surgery.
different symptomology.
That is true, Your Honor.
And she did relate that within the week immediately after the surgery and the second week after the surgery. when she
Yes,
saw
that is very true, but a lot of the common after effects of a carpal tunnel surgery do involve numbness and lack of sensation to the fingers. There is, in her signed consent form, it is clearly outlined that there could possibly be injury to the nerves post-surgery.
Dr. Weiss isn't claiming that it's anything other than a perhaps expected consequence. He's
Yes.
just saying, if you get the symptomology, you should check on it and treat it. You're not denying that, are you?
No, I'm not denying that she was symptomatic of something. I am.
Your focus really is on the plaintiff's expert's use of the term laceration.
Yes.
You say that because in his opinions, he consistently referred to it as a laceration rather than as an injury or laceration, that that is not, that doesn't create a question of fact.
Exactly,
Because the
Your Honor.
opinions, because the fact is inaccurate.
Exactly. He relies on the speculation that there may or may not have been a laceration of the respondent, but we in fact know from the record that there was no laceration. The neuroma incontinuity formed on an intact nerve.
Anything further?
Nothing further, Your Honor.
Thank you, counsel.
Good morning, Christina Sunsire for respondents. May it please the court. This is a straightforward delay in diagnosis medical malpractice action, and it is a straightforward factual dispute such that summary judgment should be denied and the lower court's ruling upheld. Really, this comes down to nomenclature, and I had two analogies that may help the court understand. The first is with respect to a laceration. So if you analogize the nerve to something like an electrical wire, you can certainly cut through the wire all the way to the plastic sheath on the other side, which results in a loss of function, i.e. you can't turn the lights on, but the argument would be that the wire is still intact. The other is to the idea of the neuroma. So if you think of an injury to the skin, a laceration would be the cut, and the neuroma is the scar. So in this particular case, to really simplify it, what Dr. Weiss is saying is that you had a plaintiff who underwent a carpal tunnel release. Directly after the carpal tunnel release, she has new symptoms that she hadn't had before. That is numbness in the digital space. There was at that point, his opinion is that the injury was a laceration. And that's his opinion because she'd undergone this carpal tunnel release where sharp instruments were being used in the hand as opposed to a neuroma that's caused by something like a crush or a stretch injury. His argument there is that the defendant here, Dr. Grimm, should have taken steps to diagnose and treat the injury, and that the window to do so that gives the plaintiff the best chance for a good outcome is 10 to 21 days. Here, the surgery was June 3rd. She's actually seen in his office twice in June. She sees Dr. Grimm in October. We're now talking 2 months after the surgery. And even there, he says, we can wait an additional couple of months, and she doesn't undergo any nerve testing until October when the window had passed. By the time she gets into the exploratory surgery and the repair in February, a neuroma in continuity had formed, which is essentially a group of abnormal cells in the nerve. The fact that there was some continuity in the nerve is inconsequential. And I would ask that this court, if it has no further questions, uphold the lower court's ruling.
Thank you. Case 604, Liberty Warranty Corporation versus Fucillo Automotive Group, Inc. What did I say?
Also watch TV.
Good morning.
Good morning, counsel. Proceed.
The court, Stephen Blatt for the appellants. As your honor are aware, my client is an automobile group. They entered into a series of contracts with two other parties. The appellees were ostensibly the broker, we say also a fiduciary to them, and then there was a third party called Interstate, who was the administrator of these programs. The dealership group sold warranties and aftermarket products like service contracts. In moving to dismiss, the three types of claims that the trial court dismissed were the fraud claims, the conversion claims, and the breach of fiduciary claims. I respectfully submit to the court that from a 30,000-foot view, there was no analysis of the substantial and detailed allegations of the appellant considered by the trial court with respect to its decision, its written decision. With respect to the fraud claims, the trial court merely said in a conclusory statement that there was no particularity with respect to those claims. The representative...
You agree specificity is required?
Correct.
Right.
Correct, absolutely. With respect to that, the representative, the complaint and the affidavit submitted in opposition to the motion to dismiss, which was supplemented the complaint and accepted by the court, described in specific and high detail a meeting that occurred with representatives of both the appellants and the appellee. It described the date, it identified where it was, it identified who was there, it identified what was given to the appellant by the appellee. It identified that these spreadsheets and Excel spreadsheets were later found to be fraudulent and incorrect. It identified that after the meeting, the appellant's representative asked the appellee for a copy of those, what he found later to be fraudulent spreadsheets. It identified the date he asked for them. It identified the emails. It attaches to his affidavit the email requests. It attaches to his affidavit the response with the spreadsheet that he later found to be fraudulent. It attaches, he says there were hidden cells on the spreadsheet, which raised his curiosity. So he went to the third party, who's not a part of the lawsuit, and he asked them for their financial information as to the programs between the parties. It gives the email. It shows the response with the email. It identified who he asked, who he got it from. It shows that the spreadsheet that he received from the third party, non-party Interstate, was different than the spreadsheet that he received from the appellee, and it was then that he realized that the appellant was defrauded.
So counsel, let me ask you this.
Yes.
So you're making reference to the spreadsheet, you're making
Yes.
reference to the additional information they got from, was it Interstate?
Yes.
All right, and my question is, was there a comparison of those two documents with specificity as to how they were fraudulent?
Yes, Your Honor.
And was there a drill down on the spreadsheets, or was it just that, here's a spreadsheet, this is different than that spreadsheet? That's the question, I think,
Yes.
before this court.
Absolutely.
Is there sufficient specificity in the papers, in the record, to demonstrate that there was fraud allegations to allow your opponent to be aware of what the specific allegations are?
Absolutely, Your Honor. The spreadsheets were attached in the affidavit and in the complaint. He goes into detail as to explaining how there was something called a no chargeback fee. There's columns with respect to the no chargeback fee in both of the spreadsheets. He says that in the meeting, they were told, or for 20 years, they were told that the no chargeback fee was going to be X. He shows how in the Interstate spreadsheets, the no chargeback fee was significantly more, and that's how the client was damaged, and that's the comparison that he sees. He also says that there were reserve columns that were different with respect to these warranties. You set up reserves. If somebody submits a warranty claim, then you have a reserve that's drawn down upon. He explains how the no chargeback fee was increased without my client's knowledge or consent because there was not sufficient funds in the reserve columns. So one of the parties, or both of the parties, other than my client, were allegedly experiencing losses. So without their knowledge, my client's knowledge, they took from one bucket and they increased it. And it's all there in the two spreadsheets, and the columns are different, and it's explained in the complaint and is explained in the supplemental affidavit.
We'll take a look at that, Counsel.
Thank you, Your Honor. And if Your Honor wants the record, it's on 210 and 211 of the affidavit, and then the spreadsheets that I'm referring to with the different, with 221 and 222. And also all the emails and the correspondence and the explanation as to what he did. This was the first time that my client alleges that with respect to the fraud, even if they haven't pled with particularity, which we claim they most certainly did, it's alleged that the appellee was the sole possession of the information that was always filed to my client. So this was the first time that my client was able to get information from the third-party interstate. So they were in possession of the information. So as the source of the information, my client, if they were found to not have pled with particularity, it's all in the possession of the appellee, and there should be more lenient with respect to how they should plead with particularity. In addition, Your Honor, the fraud claims are separate from the breach of contract claims. These contracts were renewed every 2 years, and every 2 years my client relied upon these representations as to what these fees were going to be, the chargeback fees, how the commissions were going to be split, how the reserves, how much money was going to be put for the reserves. And he was told certain amounts, and they agreed to certain amounts, yet when he saw these spreadsheets, these numbers were all manipulated, and every time they renewed these contracts, they were induced to enter into these contracts fraudulently. Finally, with respect to the fraud claims, Your Honor, because there are breach of contract and fraud claims, this is just the pleading stage. This was a motion to dismiss. It's Hornbook law that my client was permitted to plead in the alternative. The other two claims are the conversion claim and the breach of fiduciary claim. With respect to the conversion claim, first the court said that my client failed to demonstrate that the appellee exercised dominion or interference over my client's funds. I submit respectfully that that's not the proper standard. My client doesn't have to demonstrate anything. They're not required to lay their bare proof. That's for a summary judgment motion. All they're required to do is allege and satisfy all the elements of a cause of action, which they did. And they did most certainly allege that there were commissions that the parties were supposed to split 50-50, and because of the fraud and the breach by the appellee, that the appellee got more money than it was entitled to. Same thing with the breach of fiduciary duty, Your Honor. The court just completely ignored the specific factual allegations submitted by the appellant. Again, there was no analysis by the court as to these allegations. And again, the court applied a standard in which it required the appellant to demonstrate some of the elements of the fiduciary duty. Specifically, they said that there was no special duty or relationship. My client's not required to demonstrate anything on a motion to dismiss, but they most certainly did allege how there was a duty between the parties. There was almost a 20-year relationship between the parties. My client relied upon the appellee's expertise. They got all of their information with respect to the business arrangement between the three parties from the appellee. The appellee, even in one of its papers, admitted that, quote unquote, that its relationship with my client was built on trust and confidence, and that my client understood the unique skills, knowledge, and expertise that the appellee brought to the table. So to me, Your Honor, that's an admission that the appellee is making, that there is a duty between the parties.
Thank you, Counsel.
Thank you.
Good morning, or good afternoon, Your Honor. Sarah O'Brien, Barclay Damon for the respondent. Briefly, I just wanted to start off by explaining at a high level this relationship. My client, Lawley Automotive, is a broker, and they are essentially the business relationship manager between Interstate, which is the third-party administrator of this program, and Fusillo, the automotive dealer. So as I'm sure Your Honors have all gone and purchased a vehicle, you go in, you purchase the car, and they try to sell you this the limited warranties. In this case, I'm going to use random numbers, but they're similar to the case here. You buy the limited warranty package for, say, $2,000. The cost of that package is probably around $500 or $600 to Fusillo. That cost includes the payment into the reserve account, the payment into the no chargeback account. A piece goes to Interstate to purchase insurance. A piece goes to Interstate as their profit, and a piece goes to Lawley for their commission. Small commission, probably $50 total on the sale of one of these contracts. The profit that Fusillo makes is about $1,400. So the difference between the cost, the $600 and the $2,000 that the customer pays. What's important to note is that customers had the ability to cancel these contracts, and many of them did cancel these contracts. And pursuant to the agreements, which are in the record, the no chargeback agreement stated that Fusillo was entitled to their profits no matter when the customer canceled the contract after 90 days, which many of them did. So Interstate, the program administrator, was required to refund the customer the full $2,000, and while Fusillo kept their full profit, their $1,400 profit. So as this relationship progressed in 2019, Interstate was suffering significant losses as a result of the inadequate no chargeback fee. And that's all alleged in the complaint. So during this time, and during the time of the spreadsheet in 2018, when the spreadsheet was allegedly circulated, my client, as the broker, was trying to illustrate the inadequacy of the $85 no chargeback fee. So the reason for the quote-unquote hidden cells in the spreadsheet was it was illustrating different no chargeback fees and different reserve ratios as it related to Fusillo's profits and Interstate's significant losses. It's also important to note that Interstate, pursuant to the dealer agreement and the various other agreements that have been entered into and are in the record, had the ability to offset its losses from the reserve account in any way related to Fusillo's business. So all that as background, it's important to know that
Isn't your argument here, though, I mean, you've given us the background, we're familiar with the background, but your argument is the specificity problem, right? That when you drill down on what the claim is, it's not specific enough. They make reference to the spreadsheet. There's reference to the second document from Interstate that they received. But beyond that, there's no drill down specifically on where the fraud occurred.
Absolutely, Your Honor. And your question to Mr. Blatt was right on point, and his response was that the damages resulted from Interstate increasing the no chargeback fee without their consent. Lawley had nothing to do with that. All they were doing was illustrating the various different rates and how it would affect the profits.
Counsel, I'm not trying to complicate it, and the facts certainly aren't difficult. You're telling us, as I understand it, your position is that the trial judge got it right.
Absolutely, Your Honor.
Okay, you're asking us to affirm the trial.
That's what I am asking, and I would just...
There's no cross appeal where you...
There's no cross appeal. There is a breach of contract claim pending that we believe encompasses all of these claims that has been ongoing, in the court below for many, many months now.
Your position also is Lawley isn't a fiduciary?
They are not a fiduciary, Your Honor. They actually are a fiduciary of Interstate, not of the dealer, and have entered into non-disclosure agreements with that to not disclose their pricing. But not only did the court get it right when they said that the plaintiff did not allege sufficient particularity, but also we argued that the plaintiff's claims are barred by documentary evidence, namely the settlement agreement that Fusillo executed with Interstate for around $3 million for the exact same claims that it's asserting against Lawley, as well as the various agreements set forth in the record three, and alleged in the complaint, three of which Lawley is not a party to, and two of which support the same facts that we're discussing here, that Lawley had never had any control or dominion over any funds, and that goes to the conversion claim. Also, I would
You
just
should
want to
begin
mention.
to wrap up, counsel.
I just want to mention the fraud claims are also duplicative of the breach of contract claim, and
Which survives.
absolutely, and the plaintiff admits that the various claims that it makes as it relates to the fraud claim are governed by the various agreements. Just briefly, as it relates to the conversion claims, Fusillo failed to allege dominion or interference over any funds. It never had control of any funds. That's very, very clear in the agreements and in the affidavits that have been submitted in support of the papers. And Fusillo even admits in its brief that it was Interstate who exercised dominion and control over the funds. Briefly on the fiduciary.
Your time is up.
Okay, thank you, Your Honor. I just want, very briefly, I just want to make sure that that it's addressed that the claims against the individual defendants, I don't believe that was addressed in the plaintiff's paper, but those should also be upheld, the dismissal against the individual.
Thank you, counsel. Okay, very good. Case 608 to 616, matter of Brighton Grassroots LLC versus Town of Brighton Planning Board et al. Justice Smith is recused on this case. I think everybody's situated. Proceed, counsel.
Good afternoon, Your Honors. To your point, to try to speed this along and make this efficient, we've split up part of the argument. Mr. Zoglin's going to speak after me. I don't anticipate either of us are going to go the full time. And only if there's something that needs to be addressed at the end, Ms. Bloom will handle that as well.
Very good.
I'm Aaron Sakin. I'm the attorney for Appellant Save Monroe Ave and the Save Monroe Ave parties. I'm arguing on behalf of all of the petitioners. I'd like to begin with what is essentially the fundamental big picture issue that has led to the specific problems and issues with the court's denial of the preliminary injunction and why we're here today. The fundamental problem is this. In February of 2021, Brighton Grassroots makes a motion for a preliminary injunction. Court issues what I call the initial injunction, right, to protect the Auburn Trail, which runs through the project site with fencing.
That's still in place.
Actually, it has been removed. The court has allowed the fencing to be removed while some of the construction still continues, which I'll touch on in a moment.
Okay.
So
That's not in this record, though.
that is not in this
Not
record. There is a decision that the court could obviously acknowledge. It's a published decision. It's on the docket. Going back to the initial injunction, the court found a few things that I think are critical, right? Number one, that the Auburn Trail was worthy of protection, right? That was the overall.
We're not here arguing on the initial TRO that was converted and whether it's in place or not or removed but what we're doing is this preliminary injunction that you applied for, that the court did not grant. Should we interfere with that court's exercise of discretion or whether that and the only issue for us is, has that discretion been abused? And your argument is it has been abused.
It has, yes. And I can give you a few specific reasons why. I was just trying to set the table to explain why this.
It's not like we haven't seen this case before.
Right. I understand that.
We've seen it many, many times, and many of us have been on the different panels. So the background is there. I'm just trying to understand on this particular case how you believe it's an abuse of discretion for the court to deny the preliminary injunction.
One of the fundamental specific problems, which is I think what you're getting at, it doesn't correctly address And it doesn't even address all of the criteria for a preliminary injunction. And the reason it doesn't, which is why I was not necessarily giving background, just explaining the prior decision, is because it held in that prior decision that the opponents had a likelihood of success on the merits of their trail claims. It also held that the interference with the trail would irreparably harm the petitioners, right? And it also held that the balancing of the...
The court pretty clearly addressed that it's not law of the case as far as the court is concerned. Certainly on preliminary injunctions, it's not a law of the case in a grant of one, and it's the same judge who didn't feel it was necessary in this case.
I understand. I think we disagree on the law of the case issue. Mr. Zoglin was going to address that. But my point is this. The decision that we're challenging, which is what you're asking about, Justice Nemoyer, doesn't even talk about the likelihood of success on the merits. It doesn't even use the words irreparable harm.
So let's assume that none of that has changed. You know, let's assume that we agree with you, that there still is a likelihood of success on the merits. There's irreparable harm. How does the relief you're seeking with this injunction is to halt construction of the entire project? I don't see a connection between interference with the trail and halting the construction of the entire project, because really the basis for the most recent preliminary or application for preliminary injunction was that there was still interference with the Auburn Trail, right?
Correct. And that interference, I think this is what you're getting at, isn't just from construction. We also sought to enjoin the operation of the opening of the remaining of the plaza. I mean, there's two levels of interference, and I think we've presented the photos, which is clear and convincing, and I think it's obvious that we have met that standard. You've seen construction vehicles not just crossing over the trail, but driving on it. You've seen the fence previously removed. You've seen the trail blocked. I mean, it's dangerous and somebody is going to get hurt. That's construction. Then there's the danger during operation. And if the court has seen the site plan, it can see that the trail is effectively being erased, right, through this process. Nowhere, once the portions of the plaza open and operate, how do the pedestrians know where those actual public recreation easements are that run through the plaza? They don't. How do drivers know that people are going to be riding bicycles?
So if there's interference with the trail, it seems that the argument is that the injunction, the preliminary injunction that was granted is not being followed. Why didn't you make an application for contempt?
Our argument with respect to the injunction and our argument here is that it was insufficient, right? It was insufficient to protect the trail. He allowed the trail to have temporary fencing, but they could be removed almost essentially as needed. It's an insufficiency argument. It's not a contempt argument. So what happened was you had the court below at one point say the trail is worthy of protection, right? And then several months later, we come back with photos of what was actually happening during the construction. We plead to the court, enjoin construction and operation of the plaza. I think the proof was overwhelming, and at that point, the court was not comfortable and did not want to order the developer to stop building. If you look at I referenced the site plan before. The developer has constructed a bypass. You've probably heard about this in the briefing. The bypass directs pedestrians away from the plaza. The reason why the town required the developer to build the bypass was because they know it's not safe for pedestrians, and it's already open. They know it's not safe for pedestrians to use the actual public recreation easements that run through the parking lot of the plaza. There's going to be hundreds of cars going over that every day, maybe more than 1,000. 14 tractor trailers a day minimum delivering to Whole Foods. If you look at the decision that we're challenging, there's no discussion of likelihood of success on the merits.
Let me just backtrack. That parking lot that you were talking about, you're talking about the part of the parking lot that will go, that at least that the plan provides for, that will going on the trail itself?
So
is that the part of the parking lot you're talking about when you say the cars are going to go all over it?
Every day, cars will be going over the trail.
I thought that the injunction that was in place prohibits constructing the parking lot in the area of the trail, at least for now.
That injunction has been The developer has sought relief from that injunction, and the court has allowed it to take the fencing down.
Right, but that's not in our record right now.
That is not in your record.
Okay.
That's correct. But at any rate, what you have here is interference. I want to talk a little bit about the irreparable harm, which the court did not address. It literally said in a lone sentence, and this is important when talking about the balancing of the equities, and I'll explain what I mean in a moment. It says, this court is unmoved that extra safety measures are needed to stave off any harm. There's no reference to irreparable harm. It doesn't even say those words. What the standard is, there's no analysis, there's no comparison at all. At best, it's talking about remedies. Courts have repeatedly held public safety risks constitute irreparable harm. Also, interference with property rights constitutes irreparable harm, including blocked access or encroachment. 99% of the cases when you're talking about property rights and irreparable harm, talk about private parties, right? Neighbors and driveways. We're not talking about private parties here. We are talking about the public and the public's right to access those recreation easements. I don't know how you could come up with more clear and convincing evidence that the public right to access those recreational easements is being interfered with. That is irreparable harm as a matter of law. The court found that that was irreparable harm when it granted the initial injunction. And then it sort of completely reversed its posture about that trail being worthy of protection. Here's where it goes wrong as a matter of law, all right? You can't do the balancing of the equities test, which the court below did, without addressing irreparable harm. Why can't you do that? It's literally part of the standard. I'll read the standard that the court articulated in the Felix v. Brand Services Group case. Such a balancing involves an inquiry into whether, quote, the irreparable injury to be sustained is more burdensome to the plaintiff than the harm caused to the defendant through the imposition of the injunction. Nowhere in the court's decision does it do this. It doesn't address the irreparable injuries to the petitioners and the public, let alone doing the comparison. It skips it, and it skips it because the court had reversed its posture. That's what we're getting at. Had the court actually analyzed the irreparable harm issue as required, it would have concluded that the harm to the developer, in contrast to the harm to the public, the harm to the developer is purely monetary. That's what the undertaking is for. I mean, look at the harm. We're talking about public safety, and it's about to get much worse, right? If and when that portion of the plaza becomes operational, the portions closest to the trail.
Counsel, you should begin to wrap up.
Okay. The other point I was going to make is that it is an abuse of discretion to deny a preliminary injunction motion when it's clear that the plaintiff has met its burden by clear and convincing evidence. I think we've done that. That was the case in the Kangemi case that this court issued, the decision it issued in 2020. Also in Montauk Star Island Realty Group, 111 82nd 909. We would ask that the court please reverse the decision below. It was an abuse of discretion and grant the preliminary injunction.
Thank you, Counsel.
Good morning, and may it please the court. Jacob Zoglin for Brighton Grassroots Appellants. I'd like to start off by just reiterating that we've split up the arguments, and PGR joins in the arguments of SMA and Clover Ellens Creek as well. I'll jump right into one of the main issues that I'll be tackling here, and that's a big issue on appeal, which is the lower court abused its discretion because it previously granted BGR a preliminary injunction, what's been referred to as the initial preliminary injunction or first preliminary injunction, which specifically found that BGR is likely to prevail on the merits of the Auburn Trail claims. Those are the public trust and permissive referendum claims you're familiar with. The BGR and the public safety concerns constitute a sufficient irreparable harm that was part of the first preliminary injunction, and that the equities tipped in our favor. But later, on the preliminary injunction that's the subject of this motion, and this goes to Your Honor's question, Judge Nemoyer, on the preliminary injunction that's the subject of this appeal, the lower court reached an inconsistent conclusion, even though the two motions from the first preliminary injunction and this one involved the same case, BGR's case, same issues, standard of review, burden of proof, and substantially the same facts. And one of the alarming things is when the court came out with its decision on this motion, it didn't say that the law had changed or that anything had changed. It just made a different decision that was inconsistent. So under these circumstances, the court abused its discretion by denying appellant's motion and, in effect, allowed respondents to drastically alter the status quo, which is why we're asking for that decision to be reversed. So going first to the status quo issue, because we believe the lower court got this wrong on the one that's the subject of this appeal. As a preliminary matter, the lower court's decision was an abuse of discretion because it incorrectly determined that enjoining new, additional construction would somehow alter the status quo.
Well, so why wouldn't it? The relief that you sought with this injunction was to halt the construction of the entire project, right?
Right.
And the basis for that was what?
So that goes to, which I believe was the second question that you asked Mr. Sakin, which is, what's the connection between the trail interference and halting construction?
Exactly.
And there are a couple connections. One is that, and we saw this at oral argument last month on separate motions in Supreme Court, the developer admitted that construction, internal construction, which will continue for 6 to 8 months afterwards, at least, depending on supply chain issues, will still require multiple deliveries, tractor-trailer deliveries per day. So they've admitted that there'll be daily costs.
Is that part of the record before us?
It's not, but it just came up.
Yeah, let's stay with the record that's before us.
Yes, Your Honor.
Right.
So there are things that are in the record, which are they submitted to the planning board. The operation will require 2 tractor-trailer trucks per day, plus I believe it was 8 to 12 what they called box trucks or refrigerator trucks. And there'll be trash haulers coming in, and every time these tractor-trailers come in and they cross this public easement, they have to go in and then they have to back up, all while the public, who has been using this pathway, these easements for decades for this purpose.
But doesn't the current injunction prohibit the developer from interfering with the trail? The injunction that's already in place?
No, Your Honor, it requires fencing oversight to the maximum extent practicable. But as Mr. Sakin alluded to last month, the court conditionally granted their developer's motion to modify or vacate and has said that, satisfy these conditions, the fencing can come down, and they're going to allow that fencing to come down and allow internal construction to proceed even with these known interferences without the protections that we're seeking. So the injunction that's the subject of this appeal is very much relevant to preventing the irreparable harms that will come from both finishing the external construction, which is not complete, and finishing the internal construction, which will take several months, and of course the irreparable harm that will be caused from operation. I don't want to get too much back into the issues that my colleague already covered, because I know that they've been covered quite substantially. So what we're seeing here is that the new and additional construction will alter the status quo, because the status quo that existed for decades was that people could use these recreation easements in this location without having to dodge tractor trailers, without having to dodge refrigerator trucks and trash pickups going forward and backward over the trail. Enjoining the construction would preserve that status quo. And to support that argument, BGR's appellate brief cited a couple cases, including the Wurzburger case and the Beach case, which held that in situations like this, preserving the status quo means enjoining actions that jeopardize a right to use and enjoy property. That's what we have here. We have easements that guarantee our clients and the public the right to use and enjoy these recreational easements that cross the entire project site uninterrupted. So those cases are directly on point with this issue, where it's undisputed that the public has used and enjoyed these easements for decades, and that there are easements that provide a good faith basis for those actions. And coming back to another question that was asked, which kind of touched on the law of the case issue, the decision appealed from was also an abuse of discretion because it violated the law of the case doctrine and was inconsistent with the court's prior determination on what we've referred to as the first preliminary injunction decision. Again, same case for BGR, same issues, standard of review, and in that decision, Supreme Court found that BGR had a likelihood of success on related to the Auburn Trail claims, and that the new diverted trail, the fact that that's complete does not undermine the need for a preliminary injunction, as the public still has a right to use it. The developer conceded that that's what the Supreme Court said in page 17 of their brief, and the town incorporated their brief. So we're all on the same page about what the first preliminary injunction said. It also applied to the argument about irreparable harm, because that injunction, the Supreme Court said that the public still has the right to use the trail. Public safety risks are a sufficient irreparable injury for issuance of the preliminary injunction, and that harm was enough for the issuance. But the lower court inexplicably ignored that harm on the motion and didn't explain why.
And that's your concern. Your concern is that there was previous findings, and now the court's reversed itself essentially, and without explanation, and by not explaining, that's an abuse of discretion, and that's why you're here.
Correct, and it's inconsistent with their prior determination.
I understand.
Now, to respond to what respondents have argued in their briefs.
Be mindful of your time, counsel.
I'll summarize it. They argue that you can never have law of the case with a preliminary injunction. That's not true. The actual case law says you can't have law of the case when you apply a decision on a preliminary injunction to the merits. But we aren't doing that. And if they're arguing that, it's a straw man. I won't get into that any further. I'll move quickly to just mention that we're public, trying to protect the public interest and public safety here. We have limited resources. We're not for profit, so we believe a nominal undertaking would be appropriate in this case. To the extent that that the court doesn't want to award a nominal undertaking, we've got that brief, but you can take a look at it. We believe that any undertaking should be no more than $970,000 for the Whole Foods building for a year. That's based on expert reports and affidavits with substantiated evidence attached. By contrast, the developer submitted a self-serving affidavit that was conclusory, speculative, and not based on supporting evidence. So to the extent that you reach the issue of an undertaking, we believe it should be nominal, or if not nominal, no more than $970,000 for the Whole Foods building for 1 year.
Thank you, counsel.
If there are any questions as to any of the other issues, no? Okay. I'll rest on my brief. Thank you, Your Honor.
Thank you, counsel.
Very briefly, Your Honors, good afternoon. I just want to address one point. The respondents in their papers and in this case have alleged that there is a so-called gap in the easement, and I just wanted to point out to the court that this court had that issue before it when it reversed and remanded the case, both my case and the companion cases, on the public trust doctrine claims. So that issue was before the court. It didn't differentiate. It determined that the trail covered the entire premises, or the easements rather, covered the entire premises, and the injunction covers the entire premises. And so there is no basis for piecemeal application here. And I just wanted to make that point.
Thank you, counsel.
May it please the court, Warren Rosenbaum for the developer. I will try to be brief. I know the time is getting late. We don't think the court in any way abused its discretion in denying the expanded preliminary injunction. I thought it was well within the court's discretion. There's been a lot of discussion here by appellant's counsel about things that are not in the record. I think the court understands that we've got to decide this case on the record. I think if you look at the record, you'll come to the same conclusion which the developer has come to, which is that petitioners really made no real attempt to factually establish a likelihood of success on the merits on this public trust doctrine issue. Instead, they focused on what the court said in granting the limited preliminary injunction previously, one, by the way, which the developer had essentially agreed to move the project along. BGR, Brighton Grassroots, claims that's law of the case. SMA, Save Monroe, and CAC, Clover Allen's Creek, claims that's an abuse of discretion. However you slice it, it's the same thing. The prior finding of likelihood of success on the merits related only to the maintenance of the fencing, the protective fencing during the construction, the outside construction. And as noted by the court, the developer had actually agreed at the TRO stage, and that was a large factor in the court granting the limited preliminary injunction to begin with, and that's what the court said in its decision. Based on the appellant's logic, if you grant any little piece of a preliminary injunction at one point in the case, and later when the facts are more developed, you basically get an expanded preliminary injunction just for the asking. That's not the law. The court had to take a look at the situation that existed at the time this particular motion was made, based on the record that was before it, the time this motion was made, and made a rational decision, and it was not abuse of discretion. By the appellant's logic, the fact that Judge Doyle, early on in this case, denied a motion for a preliminary injunction would have stopped everything, including all the site work. Judge Doyle denied that motion. That was never appealed, but by their logic, they could never get a preliminary injunction thereafter because Judge Doyle had denied one initially in the case. That's not what they argued before, and there should be a stop from arguing that now. So in any event, Your Honor, the denial of the preliminary injunction, the expanded preliminary injunction, by the way, would have altered the status quo. Now, the counsel for appellant Save Monroe is saying that what they asked for in the court below was not only to stop all construction, but to stop operation of the plaza once construction was completed. I disagree. That's not what they asked for. In their orders to show cause, and in their briefing up to the point of their reply brief, they never said to stop the operation of the plaza until they filed a reply brief to which we had no right to respond, in which case Mr. Sagan said, oh, we also want to expand this to include stopping the operation. But that's not what was before the court. The court was a very narrow issue, was will the continuation of construction obstruct the Auburn Trail, the use of this pathway, in a way that my existing preliminary injunction doesn't already provide for protection. And the court concluded that, no, you've got all the protection you asked for, you got all the protection you need. In any event, Your Honor, I think the court adequately analyzed the elements required for a preliminary injunction, did not overlook them. The fact that my opponents feel that the court should have been more expansive in discussing all the facts that went into his making a determination does not make his determination an abuse of discretion, which is the standard here. The appellants have asked the court to look to things outside the record. I want to mention one thing outside the record, and that is we argued motions for summary judgment last week.
I'm not considering their outside the record information. I'm not going to consider your outside the record information. We're on the record here.
Yes, Your Honor, and I agree with that. And if the court adheres to that, which I'm sure it will, then I think it'll find that Judge Odorizzi did not abuse his discretion and will affirm the judgment.
Thank you, counsel.
You're welcome.
Good afternoon, Your Honor. May it please the court, John Mancuso for the town of Brighton respondents. To keep it within the record, appellants don't seek any direct relief against the town. I would join in the arguments made by Mr. Rosenbaum here today for affirmance of Supreme Court's denial of the injunction. In simple terms, there was no abuse of discretion. The existing injunction is more than sufficient to protect the use of the easements while this matter is pending adjudication. So unless the court would have any questions, we would otherwise rest on our papers.
Thank you, counsel.
Thank you.
Recess.